You just signed a purchase and sale agreement. You're buying it from an older couple or somebody that has medical problems. After the purchase and sale agreement is signed, one of the sellers passes away. What happens next? Chances are you'll probably never face this scenario, but ultimately with the volume and transactions that we all deal with, this is bound to happen. In certain locations, if a party passes away, the purchase and sale is terminated because of impossibility. The person simply cannot buy or sell. On the buyer side, it makes sense that it's terminated because the ability to borrow money is personal, meaning a bank will not lend to an estate or an heir. The ability to borrow money is personal to the person and their credit, relying on their income and credit. On the seller side, on the other hand, it depends on where you live. In Massachusetts, a contract is not terminated due to the passing of a seller. The estate still has an obligation to comply and respect the contract. Now, that doesn't mean that you'll be able to close on time, because it really all depends on what happens on the deed. So if a seller does pass away, how does a sale actually occur? If the property is owned by tenants by the entirety or joint tenants with right of survivorship, we'll assume that the remaining parties are also in contract and will agree to cooperate whatever is necessary to complete the transaction. On the other hand, if the transaction's tenants in common, legally they are still bound, but the buyers will have to decide of whether they want to be patient and wait or not. My interpretation is that a sale cannot occur without getting probate and family court approval. If the person died with a will and left instructions that the property be sold, that's also considered a license to sell. And a license to sell permits the court to authorize the sale on behalf of the deceased through an administrator assigned by the court. Obviously, the fact that the court assigns it doesn't mean the court designates them. And a family member can apply to be the administrator of the court, or the will may have recommended or designated that person. That would be the signatory, and you simply need to get the court approval. On the other hand, if the person did not leave a will, then it's a little more different. Somebody still needs to be designated as the administrator of the court, but then you must file a motion with the court for a license to sell. The court must then approve the motion and has oversight over the sale. Since you're dealing with a contract that already exists, the court simply wants verification from the administrator that the price is reasonable and it benefits the estate. Again, on the buyer side, they simply have to be patient, and depending on the location that the property is located, it could be a matter of days, weeks, months, or longer. Unfortunately, this is too specific for each area, and obviously the answer is I don't know what the rules are in your jurisdiction, in your state. But the possibility that it can occur simply means there's real estate attorneys and probate attorneys that have a clear answer on what could happen. Is it likely to happen in your case? No. But do these things happen in day-to-day business and transactions? Yes. Not only do these things cause difficulty, but for others that are willing to wait and take the time, it might be an opportunity to purchase. So, I hope you find this video useful. Good luck. Thank you for watching. And don't forget to hit the subscribe button right there. Thank you.